Hi, everyone. It's Carrie, and I'm back for day two of the Jennifer Crumbly trial. But before we can even get to our witness, Sulky Smith, Jennifer Crumbly's defense attorney, she is throwing everything she can at the wall to see what's going to stick. You got to give her credit. She's trying to do her job. She doesn't have a lot to work with. We all kind of see it coming, right? But she's really got her panties in a wad over Ethan not being able to come in and testify. But his attorney's already said he's going to plead the fifth. He's not going to help his parents out. So the whole thing is really odd. But she's managing to piss everybody off. The prosecution and her have been going back and forth. And I will say this: she has accomplished one thing, though. She's managed to piss the judge off. Well, I'll let you hear it from the judge.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990, FD.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
And good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbley.
Just so you know. Okay, who's the first witness?
Edward Bobrowski.
And Your Honor, we're not ready.
You're not ready?
No, we're ready, but before Mr. Bobrowski comes in, there are exhibits that I have previously objected to.
Okay.
That
Who is he?
Computer Crimes, Oakland Sheriff's Office.
Okay.
It's my understanding or belief that he's going to testify to some of the messages that were sent from the shooter to his friend, who we're not going to name B. And I previously filed a motion and asked that they were excluded. I understand the court's ruling and that they're included.
Yeah, that was a year and a half ago, right?
Yep, but since that time, I have received further documents that show information that is critical to the defense from the psychiatrist who evaluated the shooter, and it appears that we have an issue that the shooter will not waive privilege.
Okay, let me ask you something. When we left yesterday, I asked whether there was any issues. I really do not like to use the jurors' time talking about these things. I'm aware of this issue. I'm frankly irritated because I feel like the court has been very timely in responding to the attorneys, and I don't, the scheduling order had a motion clocked in December, and I don't appreciate the during the trial homework assignments for the court. That being said, I'm aware of this issue. That's why I asked about it last night. I do plan to make a ruling on that. We've done some of our own research. I've gotten motions from those two psychologists, but I'm not going back a year and a half and changing my ruling that could have been appealed at that time. Well, I know that things have happened since then, but those things are subject to appeal. The motion to quash the denial was appealed. All kinds of things were appealed. This case went to the Supreme Court for a year. I'm pretty sure it was coming back, which it did. And I know that I was stayed, so you couldn't file anything then, but these rulings were made a year and a half ago, and there's reliance on those, and the Court of Appeals and the Supreme Court have not told me that that was error, that I shouldn't do that, or anything like that. And I think there was opportunity to appeal.
Your Honor, there was opportunity. We did appeal. We appealed to the Michigan Supreme Court. The court is absolutely right. The problem is, even after the motion cut off, my office received records from jail psychiatrists that I need, that has important information.
Okay, let me tell you this. We're not arguing that motion right now.
I understand. So I'm just placing my objection on the record because part of what I've asked for is that the evidence I am not going to be able to contradict that's going to come in through this witness is leaving me absolutely hamstrung. If the court rules that these psychiatrists cannot testify and the shooter is not going to testify, I'm left with this evidence coming in when I now know things I didn't know at the time And I just learned these things, and we just got the objections to these people testifying, and from Sato this week about Ethan testifying.
That is not true. That is not true. The shooter's attorney, Ms. Lofton, asserted that privilege at the time that I provided the records. The records were provided under a protective order. The records are subject to an absolute privilege that we have been researching for the past week. There's an absolute privilege, as far as I can tell. If you can find me a case that says there isn't one, I would be happy to read that. We have spent a lot of time on the homework assignment we were given while the trial is in full swing. I have found nothing that says those records aren't privileged. The privilege was asserted by Ms. Lofton at the time that you requested the records. I know it was asserted again by Sato, their new attorney, but it was asserted back in November. I could give you that date if you want. At the time that I provided those records under protective order because they could protect, the prosecution had the records, and because they could potentially lead to exculpatory evidence on behalf of your client. I didn't plan on ruling about this today, but I guess I would direct you to the Stanaway case that talks about review of records, but that's of a victim witness's records. And in that instance, there was an in-camera review, but there has to be a threshold showing that there would be relevance. I don't have that either. So I'm working as hard as you guys are right now. So at the moment, I'm not going to go back and change my ruling from a year and a half ago. I think everybody has had ample time. When something is filed, I respond to it in a very timely way, despite the fact that I have one or two other cases. And I'm not changing my ruling from a year and a half ago. You could have appealed it to the Court of Appeals, the Michigan Supreme Court, the U.S. Supreme Court, whoever. So,
Your Honor, I'm not asking the court to change its ruling from a year and a half ago. I'm asking the court to make a new ruling based on new information that I literally got this week. I literally got this week that Ethan Crumbley will not testify pleading the fifth, and that
I'm sorry, I have to interject. We brought this to the court's attention November of 2022. We've discussed this.
are you talking about the 803 statements?
All of it. All of it. And I don't mean to interrupt the court, but just to supplement what the court indicated, counsel for the shooter filed an objection in November of 22 and then filed another objection regarding privilege in October of 23. And at one of the very first hearings in this case, we talked about how it would be near impossible for this attorney to call somebody with the Fifth Amendment privilege. We have Fifth Amendment privilege. We have the privilege in the mental health code. And there's also the issues of hearsay, Judge, and there's nothing inconsistent in any of this. And counsel's had all this information.
Well, and Your Honor, I subpoenaed those three doctors. Those three doctors coordinated with my office to find time to come in and testify.
Okay,
And
how did they testify?
And then they had attorneys file motions this week while we've been in trial. And I filed a motion while we were in trial asking for alternative relief. I'm not asking the court to change its prior ruling. I'm asking the court.
I have found no legal basis for your alternative relief, and I have tried mightily.
Well, the alternative relief, I agree with you. I'm not talking about the privilege, but I'm saying when the privilege is absolute, if the privilege holder will not waive it, the court rule says, and it doesn't have to be a complainant, it doesn't have to be a victim. It says if the privilege holder will not waive it, their testimony cannot come in. And what this court is going to allow to come in through this next.
The privilege holder is not testifying.
I understand that, but the problem is the evidence coming in are statements this privilege holder made, and I have no way to cross-examine to show the inconsistencies and the important information.
I've received no offer of proof about that. I don't know if there's inconsistencies in it.
There's not. This argument isn't based on a false premise. And this is something we've been saying for months.
I know that. There's been no supplemental filing saying that there should be an in-camera review for some reason. This person is not testifying. The shooter is not testifying. So how is he someone who's providing testimony? He's not. Those are statements that were provided under 803. I was not prepared to have this discussion today because this morning. That's why I said last night. The jury is waiting. I would say that I also asked that in the Zoom we had last week. Yeah, I think it's disingenuous for the defense to say that they're surprised that the shooter would be taking the fifth. You are a very smart, very experienced attorney, and all this stuff is sitting on my desk. There's a case, Jack Maloney, right? You can't put someone on the stand knowing that they're going to take the fifth. And aside from shooter, what's your favorite color? What question could you ask him that would not implicate his Fifth Amendment rights?
Okay, I'm sorry, this has to be a clear record.
It's not going to be a clear record now because the jury is sitting there.
I asked to have the shooter brought in after the issue of privilege was brought up by the shooter's attorneys and by the attorneys for the doctors. I was not planning to call the shooter until this privilege issue came up this week.
No, the privilege issue came up in November.
On the actual records,
Yes.
not on the testimony. The testimony is all impeachment.
What testimony?
The testimony that I anticipate these doctors will give is straight impeachment of things the shooter
Judge,
said.
I need to correct the record. It is not. And Dr. Anneker informed me that she had a conversation with defense counsel last week when counsel tried to subpoena her, and Dr. Anneker explained that to counsel that it is not inconsistent. She actually
That's
said
not
that.
true.
I don't know.
That's
I
not
don't know if it's
true.
inconsistent or not. I have not read the records. I have not read these records, but the privilege was asserted at a minimum last November by the shooter's lawyer, and try as I might, I cannot find an exception to that privilege. That privilege is absolute except in limited purposes. The privilege belongs to the shooter, and it's been asserted several times. I have personally, and my staff attorney, been looking for something that would support your position. The closest I've gotten is Stanaway, and that is a victim witness, and there was a threshold offer of proof by the defense regarding what should be searched for in an in-camera review. I'm obviously not in a position to do an in-camera review of those records right now, nor have I been provided with some glaring thing that the shooter said. I lied when I wrote X in my journal, whatever it is. So.
Your Honor, I am going to put together an offer of proof of exactly what these doctors would testify to. I understand the court has not ruled yet about these doctors, aside from the fact that the privilege is absolute. I understand that. I cannot file that because of the protective order.
No, you can't file it.
So I'm gonna put it together. I'm gonna get it to everyone, and obviously we'll go from there. But I also want to state the privilege, obviously we all know the Fifth Amendment. This shooter has pled guilty. He's been sentenced. It's our position that at this point, he does not have the same Fifth Amendment rights as, for example, James Crumbley.
It's just not the
whose
law.
trial is not.
Okay, support it, because every lawyer in this room knows that sentence is going to be appealed until well after I retire.
Well, and the other thing is the evidence I intend to put in front of this jury, quite frankly, is evidence that the entire world knows about because it came out at the Miller hearing.
That's not the test for the law
You're
or the
telling
evidence.
me why it's relevant and why it would be fair to you to admit it. I understand why you want it. I understand why you want it. I haven't seen it. I understand why you want it, but I have to follow the rules. Believe me, I have been researching this issue.
Well, and I'm sorry, that's why I'm pointing to the rule about when the privilege holder won't waive it and when the privilege holder won't testify and can't testify, I'm going to the third option, which is that evidence just can't be used. If I have no
I'm sorry,
way.
this is non-testimonial evidence that's being admitted today, not testimony.
It's-
Non-testimonial evidence, I'm finished. Not testimonial evidence, and that's the basis of this court's ruling. There's no Crawford issue, there's no confrontation issue, it's non-testimonial. If it were, we'd have an issue. We don't.
And I believe the Crawford issue is preserved, and this is testimonial because this is information that is tantamount to testimony in this case.
It's not the law.
The rules of evidence, 803.3 specifically, 803.1, talk about present sense impression. I did a thorough evaluation of some of those statements at that time, which was a year and a half ago. What month was it? Maybe I'm blocking it out. I evaluated all of those statements and I made a ruling based on a hearsay exception where the declarant whether the declarant is available or not is immaterial. So whether he testifies or not is immaterial, which says to me it's separate. Those statements are separate from any testimony. The person who made those present sense impression statements, whether they testify or not. That's what 803 says. The theory behind it is that it's done in a contemporaneous way. So I made those rulings a year and a half ago, and I invited anyone to appeal anything that you wanted to appeal. There was a motion to quash. There was a lot of things appealed, and that could have been appealed as well. So it's not that people haven't, that either side hasn't had the opportunity. So I will read any case you provide. I have been researching whether or not those records could be admitted, and I have found nothing that would direct me to allow doctors to testify about privileged records that have not been waived by the person who holds the privilege, and that person is the shooter. And that privilege has been asserted repeatedly by Ms. Lofton and by Sato. I will read any case you give me, and I've been frankly trying to help you. I can't find a case that allows for that. So,
Your Honor, the only cases I can find, and I think it's because this is a unique issue, and there has probably never been a case like this, with parents who are also charged with murder type crimes, and the shooter is charged with a murder crime that he pled to. So this is a very unique situation. Unfortunately, it's a case of first impression. I know the court knows this. And so when I look at the cases, I agree with the court that most of the cases deal with a complaining witness or an alleged victim and their rights. But the court rule says privilege holder. It does not limit it to complainant. And I agree with this court. There's not case law. And that's why I'm asking this court to make a decision to not allow these statements pursuant to the court rule, because I have no way to defend them. But if the court's ruled, the court's ruled.
okay, well, I didn't plan on doing that this morning. I mean,
I will still file an offer of proof, and I will still file a list of what the evidence would have shown. And I understand the court will make a decision about the doctors testifying. That's the best I can do.
okay, well, I'm doing the best I can do.
I know you are. And
Anything else?
Just really quickly, what the court rule says is that if the privilege is absolute and the privilege holder refuses to waive the privilege to permit disclosure, the trial court shall suppress the privilege holder's testimony. I'm not done. Testimony, and this is non-testimonial evidence, what we just said. There's nothing more. This isn't a case of first impression. This is the law. It's been the law for a very long time.
well, the problem is I want the testimony, and I'm being told I can't get the testimony.
That is directed at a person who puts, like someone who is in a car accident and they're suing an insurance company and they're putting an issue. They say that I've been depressed. I can't leave my house since this accident, whatever it is. If they testify to that and then they object to having their mental health records admitted, it's problematic because that person, the witness, put their mental health issue in that case at issue. They put their mental health at issue. And so you can't use your shield as a sword. That's what that is about.
Correct.
So if you are a witness who's alleging damage to your mental health, yet you will not waive the privilege with regard to your psychological records from mental health treaters, then that testimony is stricken. There's a reason for that. You can't use your shield as a sword. That is the reason for that. That is wholly separate from this issue. With regard to asking the shooter to testify, it's not that I'm saying you can't call him as a witness, but two of his attorneys have said in no uncertain terms that he's taking the fifth. Both sides, not just the prosecutor. Again, I think that's baloney. I don't know. All of this stuff is sitting in my desk. You are not allowed to put someone on the stand knowing that they're going to take the fifth. And I cannot think of a single question beyond what is your name that would not implicate his Fifth Amendment rights. So I don't know what you could even ask him that he would answer or that his lawyers would let him answer. So It's not, I'm going to prohibit you from putting any witness on the stand who takes the fifth in front of the jury. That is strictly prohibited. So are there other questions that you could ask him? I can't even imagine. That would not implicate his Fifth Amendment rights. That's the problem. I understand your problem. I understand the difficulties. I do. And if you knew how much time I have spent and my staff attorney have spent on this, it's mind-boggling. But at the moment, I have nothing that lets me say, I have to rule in a way that is the most fair for the defendant, but goes against the law as I know it. I don't have something that lets me do that. If someone has something that lets me do that, I would be happy to hear about it. Okay, I'm going to the jury. Okay.
Thank you, Judge.
Again, only a day 2 of the morning, and we know, well, we can foresee how this trial is going to be moving forward. It's going to be exciting with them going back and forth the way they have.